Scholars Scholarship by Asian Society of International Law to attend the 7th ASIL Biennial Conference on International Law. She has also received Best Researcher Paper Award from the institutions like the Law Commission of India for her research in environmental and international law. Apart from public international law, her interest areas are environment law, information laws, international development, and international dispute settlement mechanism. Our second resource person is Ms. Kajol Mangeshkar. She is an assistant professor in law at VM Salgaonkar College of Law. She also been a part of NGO by the name Childline NGO, where her key responsibilities were dealing with sexual harassment cases and abuse of children, registering FIR, drafting complaint letters to the police station. In terms of the legal provisions, carrying out extensive investigation, in-depth research of case laws. She's also presently working under Senior Counsel Advocate J. Walho, and where she's practicing in the High Court of Bombay, Labour Court, District Court, Session Courts, and Tribunals. We are highly obliged by your presence, ma'am, and it is our honor to have you. Thank you so much for sparing some time from your gruesome schedules. Before starting the session, I would like to invite Dr. Professor N.K. Behel, sir, for his welcome note. Over to you, sir. Behel, sir, over to you. Sir, you are on mute.
Respected sir, yes, I think we would be able to hear you now. Sir.
आवाज नहीं आ रही सर.
Now you are audible.
Voice. Okay. Thank you, Janvi. Thank you very much. Okay, thank you, Janvi. There was some technical glitch. Honorable the Chairman, Dr. Amit Gupta, sir, Campus Director, Dr. R.K. Raghuvanshi, sir, Principal, Gemtech School of Law, Greater Noida, Professor Dr. Pallavi Gupta, ma'am, Professor Dr. A.K. Tyagi, sir, all the HODs present over here, faculty coordinators, Ms. Tanushree Gupta, ma'am, Ms. Tanvi Sharma, ma'am, Mr. Gaurav Saha, sir, and Vignesh Balaji, sir, from Gemtech School of Law, moderator and anchor of the day, my dear Janvi Bhati, dear faculty members and students. I, Dr. N.K. Behel, Professor of Law at Gemtech School of Law, Greater Noida, Gautam Buddha Nagar, UP, on behalf of Gemtech family and on my own behalf, heartily welcome Professor Chaya Bhardwaj ma'am and Kajol Mangeshkar ma'am to Gemtech School of Law. Dear students, Professor Chaya ma'am is an awardee of United Nations Fellowship to attend the regional courses in international law. She also has the distinction of receiving Best Research Paper Award from Law Commission of India. She is a United Nations trained international lawyer. We once again welcome you, ma'am, and we are thankful to you for accepting our invitation and sparing your valuable time for guiding our students. We are also happy to welcome Ms. Kajol Mangeshkar, ma'am, to Gemtech School of Law. Kajol, ma'am, is a practicing advocate at a beautiful place, Goa in our country. She has keen interest in extending legal help to the needy sections of the society, especially reaching to children and women in distress. She is expert in legal drafting as a promising lawyer. It's my privilege to welcome both the learned speakers for the day. We are really delighted to welcome you, ma'ams. At the same time, we are happy to know that Ms. Kajol and Ms. Chaya ma'am, they have a keen interest in academic and they have contributed various articles which have been published in various journals and magazines. We once again welcome you, ma'am, to GemTech School of Law, Greater Noida, and we will invite you to our campus again once this pandemic of COVID-19 is over. We thank you so much for accepting our invitation. Dear students, Kajol ma'am would be speaking on anti-dumping and its contemporary issues, whereas Chaya ma'am will speak on science-intensive dispute mechanism for protection of atmosphere. The broad topic will be covered under international law and international trade law. These topics are very interesting in today's contemporary world, and dear students, you will be greatly benefited by today's deliberations. Today, you will definitely learn the niceties and intricacies of international law and international trade law. Both the speakers will explain you the various concepts related with the topic depending upon the time available at their disposal. Kajol and Chaya ma'ams, our students and faculty members are very keen and eager to listen on today's interesting subject. You are once again welcome to the family of GIMS. Over to moderator, dear Janvi Bhati, please.
Thank you so much, sir. Now I would like to invite Professor Dr. Pallavi Gupta ma'am for her words of wisdom. Over to you, ma'am.
Thank you, Janvi. Honorable Chairman, Sir, Dr. Amit Gupta, Campus Director, Professor R.K. Raghuvanshi, speakers for the day, Ms. Kajol Mangeshkar and Ms. Chaya Bharadwaj, expert in international trade law matters, Professor Bahel, Professor Tyagi, dear colleague, and my dear students. A very good afternoon to all of you. As we know, we are gathered here on a very important topic, that is international law, and the part of international law as international trade. We all know that international law is a vanishing point of law. It is considered as a very weak law. Several jurists have spoken on this, that this is not a enacted law by any world parliament. It is just made by convention, treaty, bilateral agreement, by multilateral agreement. Nowadays, we have two parts of international law: public international law and private international law. International trade law is considered to have both aspects: public international law and private international law. So we have to understand what is international trade law, as no country can live without any connection with other country. It is by way of trade. There cannot be closed economy. We have to interact with the other country to get commodities for the people of their country. For example, we have no such resources for the oil, crude oil, natural resources oil. So we have to interact with those countries, those are having these resources. So it is very a natural, interaction with between the different countries. That has come forward it's a kind of multilateral agreement between the different countries, and WTO has taken shape. Now, WTO is working through several agreements. The one agreement is anti-dumping agreement. So dumping means when a company of a country exports such products at a price lower than the price which is prevailed in the home country. So what is the extent of this dumping of this product? If it is not in the interest of a country, then the country is, allowed to take measures to stop such dumping, which is not in the interest of that country. It's known as a Marrakesh Agreement also. And if complaint arises with respect to any agreement, for example, anti-dumping, that particular country has taken very strong measure, very strict measure, and that will hamper the interest of the other country which is going for the dumping. So the dispute arises, how it will be settled? There is a dispute mechanism, a dispute settlement mechanism in the WTO. So what is the requirement in WTO to settle the dispute? Nowadays, there is demand for the arbitration to settle the dispute. Although there is two ways for the settlement of the dispute if complaint comes to the WTO. It's maybe by way of bilateral or mutual agreement, but maybe if it is not done, then the adjudication part will come. So we have two speakers, brilliant speaker, those are having expertise on this. They will definitely will focus the entire thing, and our student will be educated with this. So I hope if I can see Miss Kajol, are you here?
Yes, ma'am, I'm here.
Yeah, ma'am. And Miss Chaya.
Ma'am, she will join us very soon.
Okay.
Not join us yet, but
Okay.
she is promised that she'll join us very soon.
Okay. So Miss Kajol, I welcome you, and I think our students will be happy to listen you. So you are muted. Please unmute yourself. So now mic back to Janvi.
Thank you so much, ma'am. So today's session is going to be very intriguing as Professor Dr. Pallavi Gupta ma'am and Dr. N.K. Bhel sir also explained us about the scenarios of international laws, how the trade is regulated by these laws and how important these laws are to connect the countries globally, economically. So we will be learning about international law and international trade laws like anti-dumping laws in present session. And I would request Ms. Kajal Mugeshwar ma'am to enlighten every one of us over the subject. Over to you, ma'am.
Janvi, thank you, sir, ma'am, for the lovely introduction and for having me for this symposium. I hope I'm audible. In case if
Yes, ma'am, you are audible.
lost the voice, please let me know.
Ma'am, you're audible.
Yes, I'll just share my presentation. Okay, I hope you're able to see the screen.
Yes, ma'am.
Yes, madam, is right. Yes.
So, welcome students. I'm Professor Karthik from VM Salgaonkar College of Law, and therein I also teach international law. So, this is one of the topics that we have, and it's a very interesting topic. Agreements on anti-dumping, which is our topic for today for discussion for this session. So, before we start with the topic agreements on anti-dumping, I would like to pick a discussion on the concept of dumping. As ma'am had briefly mentioned, dumping, as we know, is a process wherein a particular company's firm is selling products at a very less price in the other country. So it is an instance where a firm sells its product at a price less than its normal value. So when we speak of normal value, the product is being sold in the other country for a price that is less than the value at the home market. So here it creates an unfair competition. Okay, it creates an unfair competition. Therefore, in cases of dumping, what happens is the exporting businesses flood the importing country's market with goods at drastically lower prices, which puts the importing nation's competing firms out of business. So, it is also an act of offloading a product on a foreign market. Now, to better understand this concept of dumping, let's take an example for instance. Let's say that there is an occasion a company from France is exporting tires to the US for less than the nominal price. Now, here, what would happen is the consequences of doing this would ultimately be that in America, the local manufacturers will find it difficult to compete with the prices at which France is introducing its tires in America. Second consequences of this would be that over here there are two people who are facing a difficulty. One, the local manufacturers in America. At the same time, even these manufacturers or the company firms from France are also going to face difficulty. Now, what is the difficulty that they are going to face? Like I mentioned, dumping is when they are selling it for a price less than the market value in the home country. So, the fact being that the price of the commodity in France itself is lower than that what it is being sold. So supposedly, if say the price of the tire in France is $500 and they are selling it for $200 in America, so here France would also be facing a loss to in order to create that competition in another country. So here, why are they doing this? The reason why they're doing is to increase competition, to also eradicate competition against their products, and at the same time to make sure that there is a demand that is created for their products. Now, why are they selling it for a higher price in their own country? Because there they are not concerned about competing, but there they are establishing a monopoly. So, which is why they are keeping the prices in their own home country at higher than the cost price, but in the other country lower than the cost price. Now, the second consequences that will be faced as a consequence of selling it at a lower price is that it would slowly affect the local manufacturers, and ultimately, due to the continuous dumping of the products at a lower and cheap rate, it would force the local manufacturers out of business. Now, consequently, once the local manufacturers are forced out of business, then obviously they are going to capture the market, and therefore the capital share, the profits that they're going to incur are going to be high. Once they have established themselves in the other country's market, automatically to make up for whatever losses they have previously incurred, when the prices were kept very low, they would increase the price flow of that particular commodity in that particular place. So thereafter, consequently, France, once the US, the American local manufacturers are out of business, they would capture the market and slowly start increasing the cost of the products that are being sold. So here we see this is a cycle that goes on, wherein we see we need to distinguish between exporting a product and when is it, there is a thin line in distinguishing trading and dumping. So first we have exporting the product at a price that is lower than the normal. Thereafter, consequently, what will happen is the lower price will be set by that particular country, company's firm that is exporting the product in the other country, and it would force out the local manufacturers of that country because they would be able to compete with the prices. Once they have forced the local manufacturers out of business, subsequently we see the third there, they would slowly start increasing the price of their product. Now, consequently, once the price of their product is increased, this is done in order to make up for whatever losses were incurred previously. So once they realize that the cost, the price is slowly increasing, then we have an unfair trade practice that is taking place. So one main consequence of this whole act is the unfair trade practices taking place. So the moment there is a realization that there is an unfair trade practice going on, we have the home country that will try to protect its local manufacturers. Therefore, the whole concept of protectionism will come into pictures to put an end to this unfair trade practice. So, as a consequence of that, we have the anti-dumping duties that are introduced, which are a relief to the local manufacturers and also a relief to the unfair trade practices that are being carried out as a consequence of dumping. So the whole vicious circle starts with exporting the products in a foreign country at a price lower than the market value or the price of that commodity in the home market. Now here there are three major types of dumping that takes place. First, we have the periodic dumping. In periodic dumping, usually what happens is it's the same situation that we just discussed, wherein they would introduce the product at a price lower than the home market value, and thereafter, once the local manufacturers run out of business, they would subsequently increase the price. So this is the first type of dumping that we have, that is periodic dumping. Then there is another category of dumping, that is sporadic dumping. In sporadic dumping, what would happen is, say, let's take an instance of, this is in fact an example wherein there was this cycling company in China, and they had excessive cycles that they had manufactured. So when they had manufactured excess of those cycles, then there was a need to offload that burden from them. So in order to offload it, they decided to dump these excess of cycles operated by batteries in another country where that particular product either is not very well established or the demand has not been established. So they would take those products, the excess of manufactured products, and go to another third country and sell it there. Sell it there for a lower price, as it is they're offloading it from their own country. So therefore, for them, it isn't, instead of completely destroying it, they rather would go and offload it in another country where they would at least make some profit. And thereafter, once they know that there is no competition for that product, ultimately they would capture the market, increase and create the demand for it, and thereafter subsequently increase the prices for that product. So this situation is a sporadic dumping of products by one company in the country of another, in another country. And then we have the third category of dumping, that is persistent dumping. In persistent dumping, what would happen is, usually the prices, the product that is introduced in the third country is introduced at a value which is lower than what is the home market value, but at a nominal price, and it is maintained at that particular price for a very long period of time. So these are the three major types of dumping that take place. Now let's take another situation. What another situation that occurs in dumping is, let's say there is a particular product that is launched by a country. For instance, China. China has launched a cell phone, which the cost of production in their own country is say $250. Thereafter, China decides to sell it in another country, a third country, say India, and they are selling it in India for $500. Now here, the cost at which they are selling it in another country is $500, and the cost at which they are selling it in their own country is $600. So here, what is happening is they're selling it in their own country higher than at the price at which they're selling it in another country. This is one situation. Then let's say there is another situation of how dumping occurs. In the same scenario, the cost of production is $500. They're selling it in China itself for $600, but they're selling it in India for $450. So this is lower than the cost of production. So initially they would sell it for a price less than the cost of production in another third country. In this instance, it is India. Once they have captured the demand for that particular cell phone in India, subsequently they would increase the price value of that particular cell phone to make up for whatever loss they've incurred while they kept the price of that particular handset less than the cost of production. So these are the manners in which dumping occurs. So what exactly is the consequences and the advantages and disadvantages of dumping? So the advantages is that it increases the market share for the dumping country's industry. Secondly, it temporarily lowers the prices for consumers. So these are the advantages, the pros of having the concept of dumping. And however, it also comes with certain disadvantages. That is, it is expensive for the manufacturers of that particular country to maintain the price value. Then the target country might retaliate, and there could also be a consequent trade war. And also, it is going to be censured by the WTO and by EU. So now coming to what is the anti-dumping agreement. So like I mentioned earlier, anti-dumping agreements would come in the way of a relief which would be made to all these unfair trade practices that are consequently being carried out by way of dumping. So when they realize that these unfair trade practices are being carried out in the form of dumping, to put an end to this or to sort of bring about a equilibrium in the status of these exporters and the local manufacturers, they decided to have certain duties to be imposed, that is the anti-dumping duties. And in order to guide these anti-dumping duties, there were certain agreements that were being formulated by WTO. So we have the General Agreement on Tariffs and Trade, which was the first most comprehensive agreement that sought to regulate dumping. So under the GATT, we have Article 6, which deals with cases of dumping, and it provides that in instances of dumping, the product should be condemned if it causes or threatens to cause material injury to an established industry in the territory of the contracting country, or if it materially retards the establishment of a domestic industry. Now, a brief historical background of this particular agreement that was introduced. So initially, we had provisions only in Article 6 of GATT. However, it was found that it was a little vague and not elaborate in terms of guiding the principles of imposing anti-dumping duties. It was lacking provisions in terms of how to implement this particular provision, how to guide the investigation in establishing whether there is dumping taking place or not, and consequently, if it is found that dumping is taking place, how do they exactly impose the duties? So thereafter, we had the Kennedy rounds, wherein the anti-dumping code came into existence, which was further elaborated in the Tokyo Round Code in 1974. And thereafter, we had the Uruguay Round Code in 1986, wherein finally we had an anti-dumping agreement that came into existence. Now, this particular agreement, it clarified and expanded Article 6 of our GATT, and these two operate together in order to address issues pertaining or related to dumping. Now, speaking of protectionism, like we've seen the example, in order to keep a check on such issues, anti-dumping duties are imposed for protection of domestic injuries. So anti-dumping duty is basically the amount of tax or duty that is imposed on imported products or services. So after anti-dumping duty is imposed, the imported products and the price of the product that are imported and the price at which the particular product is sold in the importing country, that is the market value and the home market value of that product will be balanced, and there will be an equilibrium that will be created between the prices of the product that is exported and the prices of the products that are already existing in the local market. So here we have the basis of imposing anti-dumping duties. First is the price of the product is lower than production cost. Then we have the price of the product in the local market, price of the product in the third countries, then comparing the entry rate and the basically whatever is going to be the material injury or the threat to material injury that will be incurred, and then comparing the profit margins. So these are the basic guidelines that are being provided by Article 6 and the agreement to impose duties. Now, how is this equilibrium created? So here what we need to understand is when there is dumping occurring, the product that is exported in a particular country is exported at a value less than the normal value. So here we see an example. Mr. John of the USA exports machinery to Mr. Ram of India and is selling it to Mr. Ram for $40,000. However, Mr. John sells the machinery of the same kind in the local market of the USA for $42,000. So here we see that there is dumping taking place. How do we bring about an equilibrium here? So here the normal value is set to $44,000 and the export value is $40,000. So the anti-dumping duty that will be imposed will be $4,000. So here, this is a very basic and simple example of understanding how the anti-dumping duties are measured and imposed by taking into consideration various factors. So here we see we see the basic principles that we've seen in the previous slide in understanding how to impose duties. So it is the value in a third country, the normal value in the particular country concerning, and whatever is the difference in the profit accordingly will be imposed as a duty. So coming to determination of injury. So it is based on a positive evidence and involves an objective examination of a particular situation. So first we have three factors that are there. The first factor is dumped imports. So the volume of the dump imports and the effect of the dump imports on the prices in the domestic market for that particular similar product sold by the local manufacturers. The second factor in determination of injury would be the material injury to a domestic industry. So what is the consequent impact of that particular product being sold at a price lesser than the normal value, and how exactly is it going to affect the local manufacturers? And when we think about the effect, it is not only in terms of the profit sharing, the capital share of that particular company, but the larger impact that is going to be faced by the local manufacturers. It could, when we say that there is dumping taking place and it is occurring to the extent that it is going to force the local manufacturers to run out of business. Consequently, we also need to understand that there are going to be people who are going to be jobless, because shutting down a particular manufacturing unit means whoever is working in that manufacturing unit would ultimately lose jobs. So the impact is going to be vast. It's not only in terms of affecting the profit share, the cap share of that particular local manufacturer, but also the employees of that particular firm or company in the local market. So these two factors give rise to the third factor, that is a causal link between the dumped imports and the injury. For example, the trade relation practices, then the contraction in demand, development of technology, export performance and productivity of the domestic industry. So these are examples and instances of the causal link between the dumped product and the injury that will be incurred by the local manufacturers, which is taken into consideration while calculating the anti-dumping duties. So determination, the first part is the first factor that is important in understanding how to impose dumping duties is the cause of material injury. So we have determination of threat of material injury. Now, how exactly are we going to determine if there is a threat of material injury? So first, they are going to look into whether there is a rate of increase of dumped imports. So the quantity in which these products are being dumped in a particular country, that is going to firstly be taken into consideration. So here what we see, in cases of threat of material injury, it is important to understand that anytime a company is making, a local manufacturer is raising a complaint, it shouldn't be a mere allegation, but it should be imminent and should be very apparent on the face of it that there is dumping taking place and how it is going to have a threat of material injury that can be caused to that particular local manufacturer or manufacturers of that particular country. So the rate of increase of dumped imports, then we have the capacity of the exporters. Now, you're speaking of capacity of the exporters. The examples that we discussed earlier, when dumping takes place, that is, say for instance, if they are, selling the products in the country for a price that is less than the cost of production. Now, here, if we think of it, how is it that if say supposedly tomorrow once they have completely eradicated competition in the other country, thereafter they're going to increase the price, but in the meanwhile there needs to be some means for that particular company to survive, for that company firm to survive, to sell those particular products at a price less than the manufacturing cost. So here what would happen is, the country from where these companies or firms originate, they would be subsidizing or providing subsidy to these companies. So once the country provides a subsidy, then they have a security to sell these products at a price lower than the cost of production. So here the capacity of the exporters, taking into consideration these factors, whether they are being provided some subsidy. For instance, China is into the practice of unfair trade practices, wherein they dump a lot of products and offload them in other countries. And we see, citing China as an example, there are many unfair trade practices that they indulge in. That is, they provide subsidies to their manufacturers, because as a consequence of which they are able to sell the products at a cost lower than the manufacturing cost. And the other instance is manipulating the currencies so that the other countries cannot find out what exactly is the cost of production of that product in the home country. So taking into consideration all these factors, the capacity of the exporter or the exporters will be accordingly established. And then we have the third criteria, that is the likely effects of prices of dumped imports and the inventories. That is, how are they going to exactly force the local manufacturers to run out of business. Now, coming to examination of impact of dumped imports on the domestic industry. So, in they factors which are involved in examining the impact of dumped imports on the domestic industries. First is the actual or potential declines in sales of the local manufacturers. Then considering the profits of the local manufacturers and of the exporters. Then the market share of the exporters and the local manufacturers. The output and productivity of the exporters and the local manufacturers. Then we have returns on investments, utilization of capacity, actual or potential effects on cash flow, inventories or account records of the exporters and the manufacturers, employment, wages, and growth, and then the ability to raise capital or investments, and lastly, the magnitude of the margin of dumping. So these are the 11 factors that are provided for in the agreement in order to examine impact of dumped imports on the domestic industries. Now, all these factors are important. Why? Because it is important to understand that these agreements or provisions are under Article 6 of GATT is not saying that dumping should, there should be anti-dumping duties imposed to completely create a trade blockade or to completely stop exporters from bringing their products in the country. It is done in order to make sure that there are no unfair practices taking place. Now, to judge according to this, we have to understand that Now coming to the role that is played by WTO and anti-dumping. So WTO per se is not going to interfere into matters concerning dumping, but say supposedly if there is an instance where against dumping and they are imposing heavy duties on that particular exporter company firm, then after we see there will be an intervention by WTO where they would try and monitor the anti-dumping duties imposed by the country that is retaliating against the exporter country. So here we see WTO, it has the power to regulate the government's reaction to dumping activities in the other countries. If a government imposes punitive anti-dumping duties, WTO may intervene and check if the action is justified or is against the WTO free market principle. So we need to understand that the main objective of WTO is to make sure that there is a free trade practice going on between countries, and it is their objective to make sure there is free trade between the countries and a smooth flow of trading between the various countries. And if anything is going to threaten that particular free market principle, then they would accordingly intervene and try to moderate the anti-dumping duties or the punitive anti-dumping duties imposed by a particular country on the other. So the WTO allows the affected country's government to take legal actions on the dumping country. So here, once they intervene and find out whether the punitive is justified or not, and accordingly the legal actions are given, the right to take legal actions provided to the countries, but they would only try and see and make sure that it is not punitive, and even if it is punitive, it is justified. So the implementation mechanism under GATT, we have certain important provisions that are provided for apart from Article 6. We have Article 5, which talks about the requirement for the initiation of investigation. Then we have Article 6, it sets forth detailed rules on the use of sampling techniques. Then we have Article 7, it provides rules relating to the imposition of various be taken. Now, no provisional measures may be taken from the initiation of a particular investigation within a period of 60 days. So any sort of provisional measures that have to be taken can be taken only after 60 days from the initiation of that particular investigation. Then we have Article 8, it contains rules on the offering and acceptance of the price undertakings in view of the imposition of dumping duties. Now here, when we speak of price undertakings, it would be an arrangement between the exporter country and the country that is imposing anti-dumping duties, wherein they can decide whether there is actually a need to impose those heavy duties, whether the duties that are imposed can be adjusted by lowering the price value of that particular good, or selling the same product. So there could be a mutual understanding that can be entered into between the two countries, wherein the dumping country would promise the country that is imposing anti-dumping duties that they would sell the product at a normal value, or at a value that is going to not completely create any unfair trade practices. And if the other country is agreeing to it, then there will be certain price undertakings. So this arrangement is for under Article 8 of the agreement. Thereafter, it establishes the general principles for imposition of anti-dumping duties. Then they have the concept of imposing a lesser duty rule. So what they say is that there shouldn't be a punitive anti-dumping duty imposed. Every time a country is imposing a duty, they should make sure that they follow the lesser duty rule. So to impose a particular anti-dumping duty, which is not going to be very harsh and is also going to strike a balance by bringing the exporter and the local manufacturers at par. Then we have Article 10, it contains rules for the retroactive actions to be taken against dumping duties. Then Article 11, it establishes rules for dumping duties and the requirements of review of the continuing need. So usually the dumping duties are imposed for a period of 5 years. And then we have Article 12. It set forth detailed requirements of how the investigation is supposed to be carried out, the notices to be issued for initiation of investigation, then the determinations and various undertakings in terms with respect to the price. So that is being set forth under Article 12. So a brief summary of the procedure. First, a written application is made by or on behalf of the domestic industry. The authorities would examine the accuracy and adequacy of the evidence. So the evidence has to be satisfactory in order to initiate the investigation. Once they are satisfied with the accuracy of the evidence, the investigation will be initiated. Now, the investigation period would be from 1 year and not more than 18 months. Now, the main part here is instances wherein the investigation of dumping is less than 2% of the export price, and if the volume of dumped imports is less than 3% of the total imports of that particular article, and volume of the dumped imports collectively from all such countries is less than 7% of the total imports. Now, speaking of implementation of anti-dumping duties in India, we have anti-dumping measures in India are administered by the Director General of Dumping and Allied Duties, DGAD, which is the functioning in the Department of Commerce, Ministry of Commerce and Industry, and the same is headed by the designated authorities. Now, the designated authorities are given the duties to investigate and make recommendations to the government with respect to commerce recommends the anti-dumping duties. It is provisions customs tariff act 19, specifically section 99A, which talks about anti-dumping duty on dumped articles. So wherein it is found that where any product exported by an exporter or producer from any country to India at less than its normal value, the importation of such article into India, the central government may, by notification in the official gazette, impose dumping duties not exceeding the margin of the dumping of that particular article in our country. So imposition of anti-dumping duties will be carried out for a period of 5 years, which can be subsequently extended by way of a notification in the official gazette. So the process is the same as is prescribed in GATT. So first we have preliminary screening where they would scrutinize So they would check and satisfy themselves whether the evidence is accurate and adequate. Thereafter, we will have the initiation of the investigation. Then we have access to information. So access to non-confidential information is provided to the interested parties. Thereafter, we have preliminary findings. Within 60 to 70 days, they have to come up with certain preliminary findings, followed with provisional duty that may be imposed. Now, it is important to understand that whatever provisional duties are imposed, subsequently, if it is found that the provisional duty imposed was in excess of what should have been imposed, then they can claim for a refund, or it can be reimbursed to the exporter country. Then, talking of disclosure of information, the designated authorities will inform the parties of the various essential facts, and also the parties are going to be there in order to maintain some sort of transparency. For public hearings, the parties will be allowed to meet each other face to face. At the same time, the parties will be allowed to be a part of the whole investigation process to make sure that there is transparency in the whole investigation process. And then finally, we have the final determination whether there is and what is the duty to be imposed. The time limit for investigation is 1 year from the date and can be extended by the central government for a further period of 6 months. So then we have the European Union also and the concept of anti-dumping that is being provisions by EU. So EU is anti-dumping measures through economic body that is the European Commission. So if a member country complains about dumping by a non-member country to the EU, then the European Commission will conduct a 15 months investigation. Here also, it needs to establish that there is material harm that has been incurred by the local manufacturers. So the European Commission finds two other conditions before it imposes any sort of on the dumping country. So it must find out that dumping is the cause of harm or a threat to cause material injury. And it must find that the sanctions don't violate the best interest of both the countries as a whole. Now coming to case studies, here we have one instance, a case study from US, wherein there was dumping of FPDs, that is flat panel display screens, which were dumped in the US by a Japanese company. So in the 1990s, American businesses had complained of dumping of the flat panel display screens by a Japanese company in the domestic markets. So the US Department of Commerce took cognizance of these particular complaints and ruled that these Japanese companies were liable for dumping the FPD screens in the US market. And consequently, the ITC initiated an investigation and came to the conclusion that they are going to impose anti-dumping duties of 62.5% on these FPDs that are being dumped in US. Another case study of India. Here we have the complainant, that is India, respondent was the European communities. This is with respect to the bed linens. So measures at issue was a definitive anti-dumping duties to be imposed on the European communities, including the European communities that were indulging in dumping of bed linens in India. So the product at issue was cotton type bed linen imports from India. So the appellate body found that the practice of zeroing, as was the appellant's contention, was something that would be a negative dumping margin that would be taken into consideration in order to decide what would be the anti-dumping duties to be imposed. So here we see discussion as to the methods that are being involved in imposing anti-dumping duties on various countries. Another case study is advantages of anti-dumping duty. So here we are going to understand what are the advantages of imposing anti-dumping duties. This is a recent case of anti-dumping that occurred in India with respect to styrene butadiene, which was being dumped in India, a particular product. This case was decided in 12th of July 2017. Now here the authorities took cognizance of this and have made certain observations with respect to the various advantages that are there of these particular products in India. So say whatever products are being dumped and what would be the advantages of consequent duties imposed on these dumped products. So the purpose of anti-dumping duties, they have stated that is to eliminate injury to the domestic industry by the unfair trade practices of dumping, so as to create a situation of open and fair competition in the Indian market, which is in the interest of the country. And at the same time, it would also provide for an option to the consumers to opt for both. It is important to create or impose these duties so that the measures, it would not restrict the imports from certain other countries, but at the same time would not eradicate or push the local manufacturers out of business. So to create a sort of friendly and a very smooth economy in the country, it is important to have anti-dumping duties imposed. Anti-dumping measures may mitigate the unfair advantage gained by the dumping practices, which would arrest the decline of the material injury and its retardation. Therefore, it is imposed at a nominal rate and harsh measures, but something that questions or any difficulties or doubts you can ask.
Thank you so much, ma'am, for the session. It was such an enlightening session, and we came to know about what exactly is anti-dumping and anti-dumping laws, how they are important, how anti-dumping is basically measured. So if anybody is having any question, they can write that in the chat box. We will be dealing with the question at the end of the session. All right. Ma'am, am I audible?
Yes, you are.
Thank you, ma'am. So yes, if anybody is having any doubts, please write the questions in the chat box. We will be dealing with the questions at the end. Now, we have our second resource person, Professor Chaya Bharadwaj, with us. She is a United Nations trained international lawyer. She completed her BLLB from Lloyd Law College, Chaudhry Charan Singh University in 2015. Thereafter, she was selected as an international scholar at Environment Law Center, Vermont Law School to pursue LLM in environment laws. After completing her LLM, she joined Lloyd Law College as an assistant professor, where she started Environmental Law Center and served as its assistant director. She also started International Migration and Refugee Law Center at Lloyd itself. In 2018, she assisted Mr. Dyer Taladi at United Nations International Law Commission with his work on peremptory norms of general international law, just cogence. She has also received various awards like United Nations Fellowships 2017 to attend the regional course in International Law Asia Pacific. In 2018, she was awarded with the Local Pathways Fellowship by United Nations Sustainable Development for her work in environment education and youth empowerment. In 2019, she was awarded with Junior Scholar Scholarship by Asian Society of International Law to attend the 7th ASIL Biennial Conference on International Law. We are highly obliged by your presence, ma'am, and thank you so much for sparing some time from your gruesome schedule. Please enlighten every one of us over the subject. Over to you, ma'am.
Thank you so much, Janvi, for that extensive introduction. I am happy to be invited over here. Thank you so much. Thank you, Gaurav, for having me over here. The paper that I'm presenting today, or the topic that I'm dealing with today, is a topic that I and my co-author is also available in the participating session, Mr. Anmol Agarwal. So both of us co-authored this particular paper, and we asked a very topical question, which was concerning protection of atmosphere under international law. I'm going to be sharing my screen with you in order to give an overview of what we are concerned with or what we are dealing with today. All right, so under international law or under international environmental law, science becomes a very important factor, which means that the disputes that are taken up by the states to the international forums become equally science-intensive questions instead of just legal questions. And therefore, me and Anmol, both of us, tried attempting the question of if a science-intensive dispute is dealt before the International Court of Justice or the World Trade Organization or the Permanent Court of Arbitration, what would be the best forum in case it is a dispute concerning protection of atmosphere? And secondly, how do we evaluate what will be the best forum? And thirdly, are there going to be any challenges in taking a dispute forward in relation to protection of atmosphere? Now, I'll tell you why we chose the topic of protection of atmosphere. Currently, the International Law Commission, which makes international law drafts and rules which are then adopted by the states on a variety of subjects. Recently, in 2020, the International Law Commission drafted articles on protection of atmosphere, and protection of atmosphere becomes a very timely topic given the rise in greenhouse gas emissions around the world, climate change, and sea level rise. It, for the first time under international law, defined what atmosphere legally means and what would entail if a protection of atmosphere excuse me, what would entail if a protection of atmosphere dispute is taken towards an international court of dispute settlement or international forums like the World Trade Organization or the Permanent Court of Arbitration. Now, the guidelines that International Law Commission drafted recently in 2020, they're very distinctive in nature. They talk about the fact that any dispute which will be concerning protection of atmosphere will be a science-intensive dispute. Meaning what? Meaning that there will be legal questions concerning whether a state has violated norms that empower or that obliges the states to protect the atmosphere. But at the same time, what is the matrix? What is the measure of science on the basis of which we should determine if there was a violation of that obligation to protect the atmosphere? For example, at the national level, we have air pollution control units, which measure how a vehicle has violated the pollution norms. And if the vehicle violates pollution norms, which is measured on the basis of using a machine, then determines if a violation has happened or not. Under international law, how much greenhouse gas emission is a country engaged in, whether that greenhouse gas emission is violative of an international norm or standard, would currently fall within the realm of protection of atmosphere. Now, I and Anmol have taken a comparative approach, like I stated. We have compared the jurisdictional and substantial aspect of how the World Trade Organization had in the past dealt with the issue and is likely to deal with this issue in the future. Similarly, we've applied the same for the International Court of Justice and the Permanent Court of Arbitration. Now, under International Court of Justice, if a lot of you are aware, Article 50 of the Statute of the International Court of Justice allows the court and the judges to appoint experts if it is required or necessary in a case, which means if the bench or the judges feel that a case is science intensive and the judges do not have adequate scientific knowledge, they are likely to appoint an expert. Now, there are three important cases in relation to identify what has been the application of Article 50 by the ICJ. And for this, we took three cases. We took the pulse mills case, the whaling case, and the delimitation maritime boundary in the Gulf of Maine area. Now, in pulse mills case, the court did not choose to apply Article 50. The court said, we are not going to delve into the questions of science intensivity or the question of scientific facts. And they without invoking Article 50, they entered into giving a decision or a judgment. Then we have the whaling case. In the whaling case, the court adopted a differential approach, and the approach meant asking an independent commission for science on the issues involved in the whaling case. In the delimitation of maritime boundary case, which is interesting in itself, one of the parties approached the court with a review application saying that court, in 1992, you gave a judgment. And at that point of time, we did not have the technology or the science to identify what the actual scientific facts were. But 20 years down the line today, we have scientific technology to assert the adequacy of science. And therefore, they filed an application asking the International Court of Justice to review one of their previous decisions based on new science. The International Court of Justice chose not to admit the review application case. But these are the three cases in which the International Court of Justice has followed a very differential standard and not a uniform standard in identifying how to address a science-intensive dispute and what standard should they adopt to ascertain what will be the best available science. And this is International Court of Justice. The jurisdictional challenges of International Court of Justice are also there. Like I said, International Court of Justice has a very unique jurisdictional aspect. Again, it contains consent-based jurisdictional system, and it also contains a compulsory jurisdictional system under Article 36. Of course, the states have to consent to adopt to the voluntary or the compulsory system of adjudication under the ICJ statute. So this is how ICJ has in the past dealt with protection of atmosphere, protection of environment, and science-intensive environmental disputes. Moving forward with the second institution, which is the World Trade Organization. Most of us law students know that World Trade Organization is a global body which concerns trade disputes among nations. It was founded on GATT, the General Agreement on Trade and Tariff, and Article 20G of GATT allows state parties to implement trade measures to conserve natural resources, including the atmosphere and air. Now, the World Trade Organization in the past has addressed disputes which were particularly aimed at protecting the atmosphere or air pollution related disputes. One of such disputes is the US gasoline dispute, in which the need to prevent air and the need to prevent air pollution was discussed by the WTO panel. In future, one of the reports of WTO recognizes that WTO may adjudicate cases concerning carbon taxes or concerning trade and protection of atmosphere related disputes. Now, in such cases, how is WTO likely to address the science aspect in the dispute that will be raised before the WTO? We can definitely draw from the existing codified rules of WTO. Article 13 of the dispute settlement body procedures allow the court to derive information from scientific experts and appoint third-party scientific experts like amicus curiae, intergovernmental organization, group of experts, individuals, or they are also empowered to collect information from alternative sources. States have a very different stand in this regard. States, just give me a moment, please. Now, states have a very different position in this regard. States like the United States has openly stated that on one particular issue, there cannot be a one science, because the factors that are taken into consideration to reach a particular conclusion may be different. For example, in the pulse mills case that we discussed in regard to ICJ, both the states used different models to adjudicate different scientific issues. My co-author, Anmol Agarwal, had actually been key instrumental. He's been the expert voice on this particular issue. And and with the permission of the organization or organizers, I will ask him to make a few comments at the end of my presentation. Now, the states have agreed, like I said, that there's no one unique scientific proposition in relation to any case. There can be differential modeling of a particular case. Say, for example, whether a particular activity is causing pollution or not. In that case, one party is likely to adopt a very different model if they're taking into consideration factors A, B, C, and not D. And the other party is likely to reach a completely different result if they are taking into consideration factors A, B, D, and not C. And therefore, differences in the aspects of modeling that they take into consideration, there can be no certain science on one particular issue. and that remains a very big challenge in international law disputes. Again, lastly, the jurisdictional, please excuse me for a minute, just give me a moment, please. Yeah, hi, apologies for that. Back to the third comparative analysis. Yes, so before moving to the Permanent Court of Arbitration, I would like to draw your attention on the comparison between the International Court of Justice and the World Trade Organization. Now, when we draw a comparative analysis on the procedures that are followed by the International Court of Justice and the World Trade Organization, we realize that they both follow a case-by-case approach, allowing each institutions to create its own procedures, meaning the discretion that both the courts or both the forums have is very high, allowing them to determine their own procedures and methods of understanding or methods of moving forward in a dispute that is science intensive and environmental issues dispute. Secondly, both the ICJ and WTO can pick and choose between the scientific facts. For example, the ICJ in the Nicaragua v. US case ended up using media reports and TV channel reports to determine factual and evidentiary content in its case, choosing what it will deem to be relevant fact for the purpose of that case. And therefore, the discretion that the ICJ and WTO has is very wide, allowing them to engage in a range of procedures. Third thing, it is important to understand that the mechanism for the settlement of scientific disputes in the WTO is very detailed out in its rules for dispute settlement under Article 13, rather than ICJ's dispute settlement procedures. The dispute settlement procedure that ICJ has contains only one particularly relevant article in case of a science-intensive dispute, and that is Article 50 of the International Court of Justice statute. Finally, the jurisdictional aspects of the jurisdictional challenges remain within the ICJ and WTO system both, and the countries may or may not choose to submit their case before the ICJ or the WTO. Now, moving forward with the Permanent Court of Arbitration, Permanent Court of Arbitration has a range of protocols, specific protocols that are detailed out in cases an environmental dispute or a natural resource law-related dispute arises. And because of the draft articles on protection of atmosphere by the International Law Commission, the term natural resources now include the term atmosphere and air. Also, for a longest period of time, the science has told us that air or atmosphere was a non-exhaustible natural resource. However, the science today guides us that air and atmosphere is an exhaustible natural resource, and therefore the capacity of air or atmosphere to give life to Earth or to sustain itself is limited in nature. Now, looking at the rules that Permanent Court of Arbitration has, contains some very unique aspects. The unique aspect is that it has a specialized list of arbitrators, which means that they already know that these are the people who have an expertise in areas concerning disputes related to protection of atmosphere, or they already know that this is an arbitrator who is an expert in questions concerning climate change, or in questions concerning sea level rise, or in questions concerning air pollution. And therefore, this specialized list of arbitrators allow the parties at dispute to know that the person who's going to be arbitrating or settling their dispute is a person who's not just specialized in law, is not just a judge who definitely holds an expert legal knowledge, but at the same time is also likely to hold scientific knowledge or economic knowledge required to settle the dispute effectively. And therefore, this particular aspect of specialized list of arbitrators is unique in nature. Secondly, they also have a list of experts, technical experts, who can then support and guide both the arbitrators and the parties at dispute during the procedures that are going on in any question that is science intensive, at the same time concerns, say, protection of environment or protection of atmosphere specifically. All right, like I said, Permanent Court of Arbitration has a much more established and much more uniform procedure in terms of proceeding forward with the science-intensive environmental dispute. We can look at cases like Kishan-Ganga dispute, the Bay of Bengal maritime boundary arbitration, Guyana v. Suriname, South China Sea arbitration. And then we can also have a look at the jurisdiction of PCA. Now the difference, a stark difference between the jurisdiction of PCA and the jurisdiction of WTO and ICJ has been in relation to the consent. Now, although jurisdiction of PCA is a consent-based regime, meaning the parties have to consent or enter into an agreement first in order to determine whether they want to get their dispute settled by the Permanent Court of Arbitration or not. The South China Sea arbitration case has been an outlier. Why? Because South China Sea arbitration case was delivered without the participation and consent of the Republic of China in the case. So the facts are that the Republic of China did not consent to the jurisdiction of Permanent Court of Arbitration and also did not appear for the oral presentations or the oral submissions of its arguments before the Permanent Court of Arbitration. So although the Permanent Court of Arbitration is consensual in nature and is consent-based method and is considered to deliver the services that the states require, in as opposed to doing a function, which is a term more likely to be associated with the International Court of Justice or the WTO World Trade Organization. There has been some outliers which question the effectivity of the Permanent Court of Arbitration. I just, before moving forward to the conclusions and recommendations, I would like to highlight the Trail Smelter case of 1948. Today, we have drafted protection of atmosphere related draft articles, but protection of atmosphere related cases can date back to as early as 1948. So Trail Smelter case was a dispute between the Canada and the US, where US approached US and Canada both agreed to take up the dispute to an arbitration in order to settle a dispute in which the US alleged that the Chinese companies were causing air pollution in the atmosphere of the United States, and successfully was able to claim millions of dollars in compensation. Now, this is in order to highlight that arbitration rules even existed before the Permanent Court of Arbitration adopted the rules. And this also highlights that arbitration is more likely to success as opposed to an International Court of Justice dispute settlement, or as opposed to the World Trade Organization dispute settlement, because the parties at every step are allowed to give consent moving forward. But then, like I said, the challenge to the system is that if they don't give consent, the parties reach a roadblock which can be difficult to remove. Now, these are our conclusions and recommendations. And of course, with the permission of organizers, I would ask Anmol to conclude our conclusions and recommendations, who's also my co-author.
Sure, ma'am. We would be honored to have him also.
Thank you, Janvi. Anmol? All right. Yes, Anmol, please go ahead.
I'm so sorry for the delay. Chaya ma'am, is your second speaker ready?
Yes, he is ready.
Hello.
Perfect,
Hello.
perfect. Yes, Anmol sir, very good afternoon.
Good afternoon, everyone.
We would love to see you also if you can switch on your cameras.
Yeah, I think this the host has to give me the access or something.
Okay. So you don't have to worry. We are getting in touch with the IT department and giving you access.
Okay.
Okay, fine. Give us 2 minutes, sir.
Yeah, thank you.
Anmol sir, you will be getting an access very soon. Yes, sir. We can see you.
Okay.
We all welcome you to our symposium on international trade law, and we would like to continue. Thank you so much.
Thank you very much. Thank you, ma'am, for that amazing introduction. Thank you all the organizers over here. I have had a good opportunity to hear Kajol ma'am also on wise words on anti-dumping. I'm very lucky enough to be part of it. So firstly, I like to add on more to the descriptions of WTO, as ma'am said, to add on to a few things. So firstly, WTO is more governed, is more a dispute body by appellate bodies and panel bodies. And they are governed under rules of DSU, Dispute Settlement Understanding Rules. Under Dispute Settlement Understanding, Article 13 contains all the reasonable arguments from the side of appellate body, saying that we can introduce technical experts or scientific experts for that matter. So it becomes very interesting on how discretion plays a role on the part of appellate body and panel body rules on the introduction of experts over here. So as to a further understanding of WTO, it becomes very nuanced on the understanding of why WTO plays a role in the part of environment per se. And for that matter, there have been a lot of cases as disputes as well as propositions by thinkers saying that how these the environment plays a part of an externality per se, and it thus becomes a part of tax. So there the proposition becomes that environmental aspects become an externality, and this tax term is known as Piguan tax. So thus it becomes very important for us to understand how science becomes a role player over here. So first of all, that the discretion has been provided to DSU per se, and there are two components by which they can arrive to a conclusion for relevant information. The first one being information through the parties itself, and the kind of information that they are providing. The information is it the best available science to conclude with, or is it not? The second proposition becomes the external sources. So firstly, it becomes a standard of review on how they are considering the alternative sources and reaching to the conclusion for scientific disputes. So it becomes very interesting to note that there are certain agreements that itself provide a considerate amount of standard of review. However, in a lot of cases, a lot of disputes, the appellate bodies and panel bodies, for example, US led 3 and Bismuth 3, even EC hormones case, there have been various disputes which have reiterated that fact that it would be discretionary on the part of appellate body and panel body to consider an information per se relevant. Thus, it becomes very important on the part of appellate body to firstly recognize whether this information is per se useful or not. However, it becomes very different in in arbitration, wherein it is clearly evident that they would have an expert who would per se tell that if this information is relevant or not. So the precursory understanding of the dispute settlement body clearly indicates that the appellate body will indicate whether the information, scientific information, is useful or not. However, it becomes very discretionary on their part, and it also shows that there is no environmental expert per se to tell whether the information would be relevant. Secondly, in that matter would be the third parties. Okay, so yeah, third parties and how they would influence the decision. Onto the conclusions and recommendations, the first conclusion could be that arbitration is a more nuanced and is a less time consuming and less practical version of it. So arbitration through PCA, we actually provide a mechanism where it is environmental aspects. It looks into the environmental aspects of the dispute. Secondly, it takes away the fact of it introduces the fact of consent-based system, wherein both the parties, if they want, they can actually consider that that scientific dispute to be relevant of nature. Thirdly, it moves away from the aspect of adversarial model. And fourthly, it becomes important on how the jurisdictional issues are being convened over here. So yeah, these are the conclusions and recommendations over here. Thank you.
Thank you so much, sir, and thank you so much, ma'am, for such an enlightening session. So if anybody is having any question or any doubts, please write that in the chat box. Any question? I don't think anybody is having any doubt, but I was willing to ask one question from you, ma'am. Ma'am, we've learned that these international institutions as ICJ or World Trade Organization or Permanent Court of Arbitration have to be completely reliable on consent of the states for exercising jurisdictions. Even in some situations, like you have mentioned, the Permanent Court of Arbitration experienced the jurisdiction without the consent of the state, even though those decisions won't be binding over the states, right? So, ma'am, what would your say over this topic, that whether these institutions, international institutions, should have a binding jurisdiction over these states? Because other side of this same discussion says that these international institutions are the productions of the states itself. So we cannot actually bind the states over those matters. So, ma'am, if you would have to give an opinion or an advice on how these institutions should work in future, so, ma'am, what would be your opinion over that?
Thank you for your question, Janvi. And in the question and comments that followed, you yourself have answered the question of enforceability, that is the element of enforceability that you've raised. Now, I agree to the fact that in the past we have experienced PCA exercising jurisdiction over over states who did not consent to participate in a dispute. The effect of that decision by the PCA or the award by PCA remained questionable due to the enforcement aspect of that award. Now, enforceability of most decisions by most forums, including the International Court of Justice and the WTO, remains questionable broadly and generally in a wider subject matter areas. And because the enforcement remains a question, the question of what should the courts, what model should the courts follow in order to bind the states by the decision that they give, there's no straitjacket answer to this question. And in my opinion, the answer would only fall down to the consent of the states. So the consent if the consent gives a site or an intention of the state to participate in the dispute, that consent cannot be considered as consent to enforce the decision after the decision comes out. And therefore, I think the willingness of the states or the soft law principle of pacta sunt servanda would guide us forward as it is. But the question of enforcement remains, I think, one of the biggest debatable, questionable areas of international law. I hope that answers your question.
Yeah, sure, ma'am. Ma'am, at the end, the jurisdiction and the enforceability is already on the concern of the state, like how aware those states are, how much they want to resolve the disputes, and that's how they want to give the consent. Thank you so much, ma'am, for such an enlightening session. And thank you so much, sir, also. So now we will be moving towards the end of the session. I would like to invite Vignesh, sir, for his vote of thanks. Over to you, sir.
Am I audible?
Yes, sir, you are audible and visible.
Okay. Thank you, Kajol ma'am, Chaya ma'am, and Anmol sir for such a wonderful session. It was really enlightening for all the students as well as faculties alike. We came to know about a lot of things, and I'd like to thank Professor Dr. Pallavi Gupta ma'am, Principal, Gemtech School of Law, for giving us this opportunity to attend this session. N.K. Behel sir, Ajay Tyagi sir, and Vijeta ma'am, Rathi ma'am, fellow faculty coordinators, Tanvi ma'am, Gaurav sir, Tanushri ma'am, and all the students for listening so patiently. I'm sure all of you would have gained a lot of knowledge out of this session. After we open up offline, we would like to have you over again, ma'am. Thank you so much. And thank you so much, sir. So, on to you, Janvi.
Thank you so much, sir. Now I would request everybody to please turn on your cameras for a group picture. Everybody, please turn on your cameras. Thank you so much, everyone. Thank you so much, ma'am. Thank you so much, sir. It was a pleasure having you. And it's a wrap. Everybody can leave the session now.